Good morning, friends and colleagues. This is to prove that you did something bad in some previous life. It means you have to listen to me twice instead of just once. Now, as trademark lawyers, we constantly deal with the interplay between three subjects, which, in English anyway, each one of them begins with the letter D. So I'm speaking of distinctiveness, descriptiveness, and deceptiveness. And about 90% of the work that we do as trademark lawyers involves the interplay between sometimes just two, but sometimes all three of those concepts. Now, I'm aware that some trademark lawyers, I think quite a few trademark lawyers in France, the judges anyway, have taken the view that descriptiveness is the main objection to registration, and that when you've dealt with descriptiveness, and if there is no problem, there's very little left to say on distinctiveness. I personally don't agree with that, and I think that the ultimate objection is distinctiveness, yes or no, and that descriptiveness is part of the process, but is not exhaustive of what you need to know. So, you'll come to see, or you'll come to hear, that I'm not particularly happy about the way some of the case law goes on the question of descriptiveness. We start, as inevitably we must, in relation to Article 6 quinquis of the Paris Convention. And you'll see in the numbered paragraph 2, which I hope, yes, it's on your screen, you can refuse registration when a sign consists exclusively, that's a key word, exclusively. There's some degree of elasticity over that. I take it to mean usually consists simply or solely, so exclusively, of signs or indications which may serve. The word may has proved to be very important. Every word is new once. And sometimes you have what looks like a new word, seems like a new word, because it is basically a new word, at least in your own linguistic or cultural environment. It's new to you, and you have to take a decision as to whether that may serve the function of descriptiveness. And then you have that list of things which are defined as designating the kind, the quality, the quantity, the intended purpose, the value, the place of origin of the goods, or the time of production. Okay, so that's a shopping list of things that you have your mind on. But the EU legislator, as you can see in paragraph 3, took it further. The EU legislator added, or altered and then added, the words that I've underlined, including those words that I have put in the bold typeface, of any other characteristics of the goods or services for which registration has been requested. Now, it could not be clearer, I think, that in the EU anyway, the intention is that anything which may be regarded as a characteristic with respect to which the sign can be descriptive of that characteristic is to be regarded as a ground of objection unless there is an acquired distinctive character. Now, what is a sign or indication? I found myself once engaged in a completely idiotic conversation. I was the idiot, speaking to some French lawyers, and I was trying to say what is okay in English, which is that a sign or indication is something which tells you something about something, okay? But when you try to say that in French, at least it came out of my mouth as quelque chose qui dit quelque chose au sujet de quelque chose, they turned to me and said, "You sound mad." And I probably did. I'm just hoping that the same won't happen here today. What then is a characteristic? So we have that list of things, the kind, the quality, the quantity. I won't read it all to you again. I think and I hope we can agree on two things. Firstly, that when a sign is providing you with information about what a trader is offering to supply, or where it comes from, or when, or where, or why, or how it may be supplied or used or consumed, must, in principle, be regarded as information about a characteristic. Now, I think that's undeniable. I'm emphasising this because I'm finding that the General Court has on more than one occasion, and so has the Court of Justice, denied that proposition, I think. Now, the second of the two propositions I want to make that I think we can all agree on, that information of the kind that I've referred to in paragraph 9, it includes, but it is not confined to characteristics which are inherent in the nature of the goods or services concerned. Now, why do I say this? Well, there were a number of cases, but the one that stands out in the Court of Justice is the Neuschwanstein case. So this is the name of the place where the famous, in English we would say fairy tale castle, the castle is Neuschwanstein. And there was an issue in that judgment as to whether the word Neuschwanstein was descriptive in relation to souvenirs. Because there's a very big business, as you know, when you have a famous tourist spot, in selling souvenirs to people that want to come there. And by the way, there's quite a big business which is carried on by companies anywhere and everywhere, not just at the location of the tourist spot, making and selling and supplying things that can be sold to tourists as souvenirs. Okay? Now, the Court of Justice said that the word wasn't descriptive in a relevant way. I think I'm being fair to them when I say that, because the concept of descriptiveness was linked to an objective characteristic inherent in the nature of the product, and said that the fact that these goods constitute souvenirs simply through affixing the name Neuschwanstein to the goods is not in itself an essential descriptive characteristic of those goods. Now, the Bundesgerichtshof in Germany had already decided that the word Neuschwanstein was descriptive, and they sit there, and in Germany, I can tell you, they're very unhappy about this piece of law. Now, I did once hear that there is a practice in some of the departments, the ministerial departments in Germany, where they mark the file and they say, this judgment is the law only in that case, unless they say it again, in which case it becomes the law more generally. That's not something I've ever seen or heard of in England, but I gather that it's not particularly strange to have seen that written on some files in German ministries and departments, but there we go. Now, the General Court has applied essentially the same approach. The most notable case in that is the case I've mentioned in paragraph 13, which is the Vita case. Am I right that the word Vita means white, at least in Swedish? Am I right? No? I think so, but maybe. No? It's essential that it means white for the purposes of this analysis. The General Court took the position that the colour white is not an intrinsic characteristic, which is inherent to the nature of the goods concerned, and they mentioned in the judgment food processors, pressure cookers and household utensils. It was also being used in relation to refrigerators, washing machines, tumble dryers and things of that kind. And at least in England, we have a habit of calling those goods white goods, and I believe the same is true in quite a few other member states, in member states of the European Union. And besides which, white is a word which describes a colour, exactly as the judgment said, one among many colours which the goods may be provided with to the consumer and offered for sale. And when they say, as they did in paragraph 14, that the colour white is not more prevalent than the others, my answer is quite. That makes it even more descriptive. It's not a special colour in any way to use for the goods concerned, and therefore when you use the word which speaks of the colour, and the colour is just the kind of thing that may be a property of the goods, I honestly fail to see how this can be a rational judgment. Now, they have followed, there's a whole line of cases, I checked and it still runs down to recent times. There's a whole line of cases following the Vita case, So you have, as you can see in paragraph 15, you have the off-white case, it's a colour, obviously. You have El Clásico, National Football League, Professional Football League, El Clásico. It's not describing a characteristic inherent in the services. The one I liked was from Hungary, which is Hell Energy. Apparently in Hungary, perhaps in other places, the word hell is used to describe a very hot process for roasting coffee beans. The General Court decided that this was not descriptive of an innate or inherent characteristic in the goods concerned, but how could they really sincerely not think it was within that list of features or characteristics which you must take into account about what the goods are, how they're produced, what they're for, and so on. I just failed to see this. Now, what should the correct approach be? Now, there was a case, it's always stuck in my mind, because I spoke to German colleagues in the EUIPO. Now, the name Winnetou is apparently extremely well known in Germany. I don't know whether it's more common elsewhere, but I'd never heard of it. And I said, well, what is this? And it's the name of a character, a fictional Native American chieftain who appeared in numerous novels and tales by an author, Karl May, published between 1875 and 1910. Now, as I understood it from talking to my German colleagues, they were astonished that I'd never heard of the name Winnetou, that I'd never seen any of the books and films, and I knew nothing about it. And honestly, it scorched into my mind. I felt that I'd had a deprived childhood because I'd never actually heard of Winnetou. Anyway, this case went to the General Court, and the General Court took the view that the Board of Appeal at EUIPO had been too general. What the Board of Appeal had said is that this word was very apt to describe merchandising goods, and you know what we're talking about here. It's all the kinds of goods you get normally in classes 9, 16, 28, and a couple of others. Now, the objection, the General Court reversed the Board of Appeal on the basis that their reasoning was excessively general and abstract. Up to a point it was. But to be honest with you, as the Board of Appeal subsequently demonstrated, this was a question of terminology more than a question of substance, because they were able, when the case came back to the Board of Appeal, to write more specifically about what the meaning and significance of the word Winnetou was. And when they had done that, they were then able to turn around and say, it's exactly the kind of word that would describe a characteristic or features of the content of goods of the kind which were listed in the relevant application for registration. And so in paragraph 19, where I think I've captured the essence of what the Board of Appeal said, because of the reputation and popularity of the character, remember this is an entirely fictional character, primarily as a symbol for the noble savage, do we still say this? I hope not. The good, fair Native American, and or as a general reference to the fictional world of Native Americans in connection with the already defined Wild West genre in film and literature, having set up the meaning and significance of the word in that way, they were then able to switch over to the goods and services which were listed in the relevant application for registration, and they were able to say, and I think they must clearly be right, it's a sign which was apt to describe the possible content or subject of those goods or goods of that kind, with respect to which the theme or the content constitutes an essential characteristic. Now, who can disagree that the theme or content of a book or a film is actually an essential characteristic of why you will want to buy it, to read it, to look at the media in which it's been exploited? Who could deny this, as just thinking of yourselves as consumers? Now, there are other examples, but this is the point at which, in my presentation, I wish to emphasize what I think is the overlooked feature. Yesterday on my bad faith presentation, towards the end, I asked a question about, well, okay, so you have wide words, computer software, printed matter, you have wide words. And within them, there are any number of different species of goods or services which may have any number of different characteristics. Now, I believe myself that the descriptiveness objection is not doing the full amount of work that it is required to do, because the judicial tribunals, I would say in the supervising courts in Luxembourg quite generally, are not taking into account the fact that a characteristic can be relevant for the analysis, even if it is only one which is an optional characteristic for goods or services of that kind. So, for example, ingredients or flavour, those are things which are entirely, well, yes, they're entirely optional in relation to certainly processed foods, and yet they should be regarded as characteristics if anyone wants to register foodstuffs, a mark for foodstuffs or whatever. So some examples. It started fairly early. Dr. No, that's a series of 2 marks. The claim was for protection of them as well-known marks. It was rejected because they had simply been used descriptively with reference to the content and character of the goods identified in the evidence on file, which was video cassettes, DVDs, etc., linked to the James Bond character and so on. I've lost it again. Sorry. You can see just appearing on the screen, I was quite surprised because I didn't know this. Okay. Is it okay? Thank you. Cannabis. There was when was this now? 2009. The word cannabis was refused for being descriptive. This was in the General Court, I think, yes. And the appeal to the Court of Justice was dismissed by reasoned order. And that's because the goods, which were wine, spirits, liqueurs, sparkling beverages, sparkling wine and champagne, so completely general terms really, especially when you're looking at wines and spirits, they included within them goods for which hemp might be used as a flavouring or an additive. I don't suppose you'd smoke any of them, but anyway, it might be used as a flavouring or additive, and that was enough to make the word cannabis descriptive of a characteristic of goods of the kind that were listed. So I'll move on a little more quickly. The same was applied to the sign manpower. Certainly in England, it's a form of expression which was used to mean, if you like, a version of human resources. That was found to be descriptive of a characteristic that those goods or services might possess. The most famous case probably for this proposition is, and the Polish judges will forgive me if I don't try to pronounce it, I prefer to say Technopole. So in the Technopole case, the sign 1000 was in principle descriptive for brochures, periodicals, etc. Why? Because the listings embraced or encompassed goods which were identifiable or could be identifiable by reference to, said the Court of Justice, the number of pages they had, or the number of works they combined together, or the amount of data they provided, or league tables, the top 1,000, this and that and the other. The word had a very strong, said the Court of Justice, strong descriptive capacity in relation to things which could be included within the wording of the goods or services concerned. So pressing on, info security was an early case. I like this. It's been cited, but not as much as I think it should be. At paragraph 55 of the judgment, you'll see it's at the end of my paragraph 26, where the court said, and I think this is self-evident, and I just wish it was not necessary to keep saying it again, the subject matter or content of goods or services, such as the publications or the exhibitions, does indeed constitute a crucial characteristic, or at least one of their characteristics within the meaning of the objection. Now, my all-time favourite case in the General Court on this subject is a case where the sign in question was do I say it correctly? Light, in English, light yoga, the yoga of light, Licht Yoga, maybe. And they wanted it for what are the usual merchandising classes 9, 16 and 41. And the court, the General Court, delivered what to me at least is an exquisite judgment. Now I'm emphasising that I think it's excellent, mainly because I did a citation search before I came here, and I found it's not been referred to by any subsequent court, and I'm thinking, hello, this is a sign of a problem, not the sign of a solution. So you'll see, I won't spend too much time on it because time is a little bit short, but the passages in the judgment relentlessly found reasons for saying, in relation to goods or services, that the mark, the sign, Licht Yoga, light yoga, was capable, that's the word may, capable of indicating quality for products, functions for others, destinations of where people are going, maybe, a yoga studio, you see, and informing people of relevant characteristics of the goods or services on offer. And I won't labour the detail, but I was impressed the first time I saw this about the amount of effort that the court and its referendaires must have gone into for the purpose of demonstrating a full force of reasoning for the way the objection was being applied. So now, I come to what I say is the correct position, which I was getting there at the very beginning, in paragraph 30. I say the correct view is that the concept of descriptiveness should correctly be applied in a way which proceeds on the basis that characteristics means attributes. I like that, in the sense that the word attributes broadens out, at least in the English language, what you're calling a characteristic. And it includes attributes which goods or services may optionally possess, and you've heard my emphasis on that, and not, peace to the Court of Justice, peace to the General Court, not necessarily inherently or intrinsically or objectively or permanently possess characteristics of that kind. Now we have some important judgments that will soon be coming, and they will probably go up through the system to Luxembourg, to the supervising courts, but at the moment they're in the boards of appeal. And it's really quite striking. I'm inferring, I would dearly love to have the opportunity to catch someone from the EUIPO here and lock them in a room and ask them for an explanation as to what's going on. But there are these 3 marks. These are marks very much of our time. Animal Farm, 1984, and George Orwell himself. They want the name of the author and the name of the book. It's the estate, it's the executors, it's the descendants of George Orwell. Now, the boards of appeal referred these 3 cases to the Grand Board. That is their procedure when they see that there is a conflict in their own case law, alternatively that there is a conflict in the case law that they're meant to be applying, and that it affects, to a very high degree, the day-to-day practice of the office. Now, you'll understand that I think they were absolutely right to take that view. Now, what they did was they referred these, and you'll see that these were referred to the Grand Board of Appeal in the middle of 2020. Now, where are we now? We're beyond the middle of 2023, and when I checked at the weekend, there was no sign of the judgments or decisions appearing from the Grand Board of Appeal. And it's exactly the point I've just been discussing with you, which is the question of whether the expressions or designations are entirely apt to describe the content or the subject matter of the books, the films, etc., etc., etc. And I know, because I had to write a decision in England, which no sooner did I write it in England, that the Board of Appeal, I forget which one it was, I think it was the 4th Board of Appeal in EUIPO, wrote a decision to exactly the opposite effect. This was the book, The Diary of Anne Frank, otherwise known as The Diary of a Young Girl. There are 2 alternative designations for it. The copyright had expired. I'm pretty sure that the copyrights expired in relation to Animal Farm in 1984. I'm not sure, but I would expect so. Or it soon will, which is why they want the trademark. And I wrote a decision that refused to allow the registration of, as an unused mark of the Diary of Anne Frank, for all the reasons I've been explaining here. And then within no time at all, there was a decision of the Board of Appeal saying, no, this is a very famous name or mark. And the very fact that it is so famous is a reason for treating it as a trademark. Now, I personally don't believe this, but we shall see. Now, those decisions will be issued. They'll be very important. I suspect that the time lag of 3 years is because they're finding the decision on the Grand Board of Appeal difficult to write within the scope of their existing jurisprudence. Hopefully, we will have the supervising courts in Luxembourg applying an intellectually rigorous analysis and some conclusions in relation to the matters which will be discussed in those judgments by the Boards of Appeal. And I would like to offer you this thought. Why is there, when was it? It was, when was the first regulation? It was 1995 or 1996, wasn't it? So here we are. We're coming into 2023 and going into 2024, and we're in an area of law where there's been an international treaty in the form of the Paris Convention since 1870, right? Good long time. How is it then that we're still discussing what on earth we actually mean by distinctiveness? And that's because, by the way, you can't discuss descriptiveness without at the same time knowing what you're trying to mean and when you're trying to say by the word distinctiveness. It's because you have distinctiveness. They're not hermetically sealed, they're on a spectrum, but descriptiveness, if you like, is at one end of a spectrum, and very strong distinctiveness, especially inherent distinctiveness, especially an invented word, is at the other end of the spectrum. How is it that we're still discussing at this point in time what we really mean by distinctiveness? Okay, well, I'm going to offer you a couple of observations and then end with a non-patented dedication to the public of my theory of the correct test. First of all, it's not properly, I think, understood that distinctiveness is actually not, it's a relative concept. So what is distinctive depends on parlance, usage, practice in your society at a particular point in time. So it's relative to what everybody else does or doesn't say or do. And another thing about distinctiveness is that it changes over time. So you have two dimensions which make it relative. What's going on in your marketplace at the relevant application date, or what the position once was, or what it may since have become. And of course, that's the theory of how you can get a trademark on the basis of acquired distinctiveness. All right. So the best I can do, having thought about this, which you do because you can't write judgments on distinctiveness without having some conception in your mind of what you mean by it, it's the capacity, I like to say the power, but that wouldn't fit with the legislation. It's the capacity of a sign to individualize, I like the word, individualize goods or services to a single economic undertaking. So instead of just, I wouldn't myself just keep repeating distinctiveness, distinctiveness, distinctiveness. I'd try and flesh it out by having that as the focus of my attention. And then the non-patented test, which I give you and dedicate to the public here today, my test for registration on any given sign is this. This is the question which defines the test. Is this the best I can say, bearing in mind that I'm looking into the minds of other people and it's not just my mind when I know there's an issue, I have to look into the public mind of the relevant consumer and all of that. The question which I think gives you the test is this sign origin specific or origin neutral? And I believe that that duality, dichotomy, I believe that gives you the relevant test. Now, if you look back, I would invite you to consider at the time when we don't know the result of the Grand Board of Appeal decisions on Animal Farm 1984 and George Orwell. Would you like to ask, actually, shall I ask you? Haha, Let's have some audience participation then. So let's take 1984, and if you meet me on my own ground and you ask yourself to decide, is 1984 origin specific or origin neutral for books, films, games or entertainment services? What is the answer you would give today to that question? Origin specific? Show of hands. Whoa. Origin neutral? You can't, come on. Am I going to assume that everyone that didn't put their hand up for origin neutral thinks more likely origin neutral? Okay, so the question is, take the mark 1984, the famous book, The Dystopian World, thought to be a work of fiction, now turns out to be a work of prophecy. We live in the world of 1984. Okay, great. Now, the copyright's expired, so if you apply my test, you meet me on my own ground, and you ask yourself, imagine you're the judge, you're the Grand Board of Appeal, is 1984, as a mark, origin specific or origin neutral for books, films, games, and entertainment services? So that, if you want to, do you want to do the test again? I'll let you resit the examination if you want to. Can you show me, who thinks it's origin specific? Come on, be bold. Okay, that's interesting. Okay, how many have I got? About 10, 12, more? 10 or 12? You think it's origin specific? Okay. Now, who thinks that it's origin neutral? Come on. Does that mean the rest of you are agnostic on this point? Because I'm not getting numbers. It's your duty to vote. You won't be allowed to leave the room until you vote. Okay. I can understand how you may feel. You'll probably tell that having written the decision I did on the Anne Frank diary case, I would be inclined to the view, without evidence of properly acquired distinctiveness, that these expressions are origin neutral at this stage. Now, the question is much more to the point. Shall we have send a questionnaire survey to the judges of the General Court and the Court of Justice to see what they may say? Right, thank you very much indeed. Thank you.
Yes, thank you. I dare to ask questions.
Can you explain a bit more? Why would you say it's origin neutral?
Because if you accept the jurisprudence which says that the theme or the subject matter is a crucial characteristic from the consumer's point of view when they wish to acquire a book or to get DVDs, or do we have DVDs, to get downloads or to go and see a film or to go to an entertainment somewhere in the form of a play, the designation 1984, I say to most consumers, is going to be indicative of what the nature, content, theme of the presentation or the book or the work is going to be. And if that's right, it's a characteristic which books, films and theatrical productions may optionally possess because it's a theme that they're dealing with. And then I say that logically that leads to the conclusion that, especially in a world in which the copyright's expired and anyone may make a version of the work, I say that in those circumstances it becomes, whether you like it or not, origin neutral. But what we demonstrated here just now is that there is still a very strong view that because something is famous, possibly world famous, I mean the Diary of Anne Frank was on a UNESCO list of the world's top, I think 50 or 100 books. Because it's so famous, it should be protected. Whereas there's another view that says precisely because it's so famous, it's a subject matter which anyone might want to produce some goods or services where that was the central theme, and that is what the designation describes. Now this polarizes, it succeeded here today, this polarizes opinions. It's the reason why, I think it's the reason why we get to the position we're in today, where you still don't really know what they're driving at between distinctiveness and descriptiveness, but all you do know is that the greater or the narrower extent of descriptiveness just moves across to see how much work you're going to allow distinctiveness or non-distinctiveness do. So the smaller you make descriptiveness objection, you're still left with the distinctiveness objection, which you have to deal with. Whereas the French judges, I think, maybe not now, but they used to say, if it's not descriptive, it's almost game over because there's nothing much left to say. And I believe, this is me, I believe that the judgment that we got from the Court of Justice in Baby Dry is an example of that. I think this was a judgment of, the juge rapporteur was Judge Puissachet, and I think that what we got there was an expression of the view that these words are not descriptive, it's a lexical invention, and that was enough to mean that the RUC, from a French perspective, should go forward. But these are controversial issues, there's a lot to be said, and I'm waiting. Andre, it's your duty to see that the Court of Justice rises to this challenge and sorts this out. Okay, thank you.
Thank you.